Hi, I'm attorney Greg Dell with Dell & Schaefer. I'm here with attorney Victor Penna, and today we're going to discuss a case against United of Omaha, also known as Mutual of Omaha, that took place in the Federal District Court of Illinois. And this case was a really great victory for this particular claimant. Can you give us some background as to this particular case?
Sure. As you said, it was a district court out of Illinois that decided this case. And it involved a claimant. She had been paid 2 years of benefits, for regular occupation benefits for her inability to work as an administrator for a company. But like many policies, like many group policies, her policy's definition of disability changed after 2 years. At that point, it was a tougher standard to meet. But during that 2-year review, United of Omaha relied on 2 in-house reviews, clinical experts who reviewed the medical records, neither of whom had actually examined the claimant in person. It was an in-house nurse and an in-house medical director.
When you say in-house, that means employees of
Right, exactly.
United of Omaha?
Both of these clinical experts actually worked for Mutual of Omaha. So Mutual of Omaha relied on both of these reviews. What the interesting part is that the medical director actually reached out to treating physicians, sent letters to several of her treating physicians asking for them to respond to her conclusions and provide reasons for their opinions. The problem is that none of her doctors responded, unsurprisingly. So none of the doctors actually sent any responses to the medical director, and United of Omaha relied on those decisions. So what was interesting about this case is that it's very common practice for insurance companies to rely on in-house reviews. There's actually a lot of court decisions where courts have criticized insurance companies for relying on in-house reviews, but it's not always wrong for them to do so. So there are also court cases allowing or saying that it was reasonable for the insurance company to rely on in-house reviews. In this case, however, the court made a very interesting point in that they applied no significance whatsoever to her treating physician's failure to respond. What they said in this case was that what essentially happens when the medical director reaches out to the doctors is it's an attempt to lure the doctor to either agree with their limited review or basically lure them into a war of diagnoses. And there's no benefit for a doctor to do that. So their silence alone, they gave no weight to whatsoever.
So that's a very unusual finding because the court, that's the challenge in this world of ERISA is that there's how many other opinions have we seen? Well, the insurance company acted reasonably because they tried to reach out to the treating doctors, but the treating doctors didn't respond.
Right.
And so for every case, there's a lot more cases that say that this particular claimant's doctor should have responded to the in-house doctor of the insurance company, but this particular court said, no, we don't find that that doctor had to respond to you. And on top of that, the review you did, we find basically ignored all the information the doctor already gave you. Now, what I think was fact-specific about this case is that this particular claimant's treating doctor had already given so much information that the questions that were being sent by the in-house doctor were just superficial nonsense type questions. And the court was like, you're asking them already what they knew. Why do you need them to regurgitate back what they told you? You're just going through the motions, but you're not acting reasonable.
Right. Yeah, there were a few things that made it actually different because, as you stated, in most cases you would actually want the treating physicians to respond with details as to why they disagree with the medical directors. But in this case, the file actually consisted of over 5,400 pages of medical records, so there was a significant amount of support in the file as it was. And also, the same in-house medical director, the court pointed out, had been found in a previous case to have acted unreasonably. So I think that weighed. And on top of that, the standard of review that applied in this case actually did not require the court to give any deference to the insurance company, which I think was huge as well.
Right. So I think basically the judge was like, look, this is kind of, I don't want to call it a scam, but basically we see what you're doing, Mutual of Omaha in this case, and this lady has so much medical information in support of her, and just using your own in-house people without getting anyone else is just not enough, and we're going to award benefits to this woman who's been suffering greatly for a long time.
Right.
So great victory for this particular lady. It's actually the second one in the last month that Mutual of Omaha has been told that they did something wrong by the courts. We just talked about another one actually earlier today on another video out of Michigan. So it was almost the same type of thing. And ironically, it was a denial after the change of definition from own occupation to any occupation. So, we see the patterns. We get Mutual of Omaha calls all the time, but this is obviously something that's going on with Mutual of Omaha on a more frequent basis, especially as of lately. So if you have a case with Mutual of Omaha or any long-term disability insurance company, feel free to give Mr. Pena or any of our lawyers a phone call. We always offer a free consultation, and we look forward to the opportunity to speak with you.